Direct supervision, background and proposed updates in response to EPA's new rule. Before we really get into what the updates that were made in EPA's new certification and training rule are, I'd like to talk about what direct supervision is and how Washington State currently handles direct supervision in different lines of work. While holding a license is required to make many pesticide applications, there is a federal allowance for those who don't have a license, often referred to as non-certified applicators, to still make an application even without a license in these circumstances. Direct supervision is the term used to refer to the allowance for individuals who don't hold a license to make a pesticide application under the oversight and guidance of a licensed applicator. Many companies use this allowance to train someone as an apprentice while they prepare to get their license. Others do have non-certified applicators who don't intend to ever get a license, as they can still perform all duties under a licensed person's supervision. In Washington State, our definition of what direct supervision means is different depending on the license type that someone holds. We'll go through the different definitions of direct supervision that apply to our license types here in Washington. Private applicators are individuals making restricted use pesticide applications to produce an agricultural commodity on land that they or their employer own. For private applicators, the certified applicator just needs to be available if and when needed. They don't need to be physically present when a non-certified applicator makes an application. The licensed applicator can be available by phone if they still would be able to get to the application site quickly if needed. I do want to mention that label requirements will always supersede our direct supervision allowances. A recent example of this is the new paraquat user requirements. Because of risk when using that particular pesticide, label requirements now specify that paraquat can only be used by a certified applicator, as you can see here from this snippet of the label. Non-certified applicators are not able to use that product under any circumstances. Checking the label is important for many reasons, and this is another area to double-check before supervising a non-certified applicator. Commercial applicators in non-forestry setting have their own definition for what is required of non-certified applicators. The commercial applicator group includes a few different license types in this instance: our commercial applicator, operator, and private commercial applicator. For all of these license types, in applications where a licensed applicator is required, the certified applicator must be physically present during the application. We use the ear and eye shot rule, where the licensed applicator must maintain visual and voice contact during the entire application. For those commercial license types making forestry applications, the certified applicator does not need to be in ear and eye shot under certain lower risk circumstances. An applicator can apply a general use pesticide using non-powered equipment without having the certified applicator in ear and eye shot. That being said, the certified applicator does still need to be on site and immediately available if needed. They also need to directly oversee any pesticide mixing and batching activities. Public operators are those who work for governmental or public entities and can apply pesticides either on public property or private property, for example in cases of noxious weed abatement. For those working for public agencies, a non-certified applicator needs to have a licensed supervisor guiding the application, either if they are applying a restricted use pesticide or if they are applying any pesticide with powered equipment. For applications being supervised by a public operator, that certified applicator needs to be on-site and maintaining voice and visual contact at all times during use of a restricted use pesticide or a pesticide applied via powered equipment. This is the same ear and eye shot rule that non-forestry commercial applicators need to follow. So, for example, we have a Washington State Department of Transportation crew in this photo controlling weeds along a highway. We can see an applicator here on the embankment. For this example, let's assume that this applicator does not hold a license. Because they're using powered equipment, it doesn't matter whether the pesticide is restricted or general use, they will need to be supervised by a licensed public operator while they make the application. So potentially, if there was a licensed applicator in the front truck here, if they can see and hear the non-certified applicator while they make the application, this would be allowable. If at any point they lose sight of the applicator or perhaps cannot hear the applicator over the highway noise, they would need to stop the application or move closer. They need to be able to see if the applicator needs help or identify a misapplication and quickly be able to communicate that with the applicator or hear if they have a question. Another group of applicators with different direct supervision requirements are those making aerial applications, no matter the license type. This could be a private applicator on their own property, a commercial forestry application, or a public employee. Aerial applications also include any kind of aerial apparatus, so that includes fixed-wing planes, of course, but also rotary wing equipment, such as a helicopter, or even an unmanned aerial vehicle, a UAV or drone. For anyone making an aerial application, the pilot of the aircraft must be licensed. There are no allowances of direct supervision of the pilot of an aerial application. This does include someone operating a drone as well. To qualify to be a licensed person supervising a non-certified applicator, the license must be completely current. Here's a license report from our website's license search feature. We'll look at the example licensee Tina Zimmerman.
For her public operator license, we can see that it has been renewed, so the expiration date and recertification cycle are current. She would be eligible to supervise an application.
On top of having a current license, the supervising licensed person must also hold all required license categories for the application being made. Let's go back to that WSDOT example. Let's say Tina is wanting to supervise this application. Her categories are the aquatic and the agricultural insect and disease. This individual is applying herbicides along a public roadway, which would require the rights-of-way endorsement category. Because Tina doesn't hold that category, she cannot supervise someone doing that kind of application. This would not be allowable. The supervising licensed applicator has to have studied and taken the exam in all of the necessary topics that would cover the application so that they can appropriately guide the unlicensed applicator. So you've heard that Washington State has had some requirements for non-certified applicators already in place. Let's now talk about the proposed updates. Historically, EPA had minimal and vague requirements for directly supervised non-certified applicators. However, EPA's new state plan does include requirements for non-certified applicators using restricted use pesticides. And be aware that what EPA considers to be using a restricted use pesticide has changed with the new federal rules as well. The new definition of who is using a pesticide is expanded to more activities than just the application, and that will come into play with new direct supervision requirements. See the video on new definition of use for more information. Because some of the new EPA requirements do go beyond what Washington currently requires, we will have to make some updates to meet those new standards. Let's go over those additional responsibilities for certified applicators supervising an application. They need to provide a few different resources to the person under their supervision. The licensed applicator needs to explain any applicable state, federal, or tribal laws and regulations. The certified applicator must provide to each non-certified applicator before use of a restricted use pesticide instructions specific to the site and pesticide used. These instructions must include labeling directions, precautions, and requirements applicable to the specific use and site, and how the characteristics of the use site and the conditions might increase or decrease the risk of adverse effects. They also must make sure the full pesticide label is made available. Where the labeling of a pesticide product requires that personal protective equipment needs to be worn for mixing, loading, application, or any other use activities, the certified applicator must ensure that any non-certified applicator has clean, labeling-required personal protective equipment in proper operating condition, and that the personal protective equipment is worn and used correctly for its intended purpose. They should also ensure that the non-certified applicator has the equipment needed for the application and make sure that equipment is in good working order. Equipment needed for mixing, loading, transferring, or applying pesticides needs to be checked before each day's use to confirm that it can be used without any foreseeable adverse effects to the applicator, others, or the environment. In addition to making sure the correct equipment is provided, the certified applicator also needs to instruct the non-certified applicator on how to use any equipment that will be used for mixing, loading, transferring, or applying pesticides. This training must be done before the pesticide is used initially and then repeated every 12 months. EPA requires that the certified applicator must have means to immediately communicate with the unlicensed applicator. As you heard earlier, Washington has different definitions of what immediate communication means under each license type. The supervising licensee also needs to make sure the non-certified applicator meets the minimum age requirement. Beyond making sure that certain things are available to the non-certified applicator, the certified applicator will also be responsible for training when a federal restricted use pesticide will be used. And remember, using a federal restricted use pesticide will include those other activities beyond just applying. This is a new requirement in the updated federal certification and training rules. Old federal rules just stated that the non-certified applicator needs to be competent, but had no real guidelines or metrics to help ensure that they are. This newly required training has to meet certain requirements that EPA feels will ensure competency, and there are a few options for how this training can occur. Firstly, if the non-certified applicator does have a current license, just not in the correct category, so they need someone with that category to supervise them, they don't need any additional training. They've already demonstrated competency through the exams that they passed. If this isn't the case, the non-certified applicator can complete handler or train the trainer programs, which are already existing trainings for agricultural applicators who also need to meet worker protection standards. There is a final training option with a few requirements that EPA will allow, and we'll talk about that as well. I won't go into the specifics of what the training program needs to cover, but there are around 30 different topic areas that EPA requires for a non-certified applicator to be trained in under this option. They're mainly safety related and are meant to prevent some of the more prevalent risks, and include topics like potential hazards to pregnant individuals and children, when to obtain medical care, how to read a pesticide label, and environmental concerns like drift. PERC, the Pesticide Educational Resources Collaborative, has expressed interest in helping to build these training programs for the different applicator groups that may need them, so there will be help available to those that fall under this new training requirement. And again, this training will only be required for the users of federal restricted use pesticides. The instructor of the program doesn't necessarily need to be the supervising certified applicator, but they do have to meet these requirements. They need to be currently certified and be either handler trained or have completed the Train the Trainer program. They also need to be present during the entire training program and available to answer questions and make sure that trainees are present and paying attention. The material also needs to be presented in a manner that those being trained can understand. So the big thing there is language, ensuring that the material or a translation is made available in all the necessary languages. And again, the training has to cover those required topics that EPA lays out in their rule. EPA also introduced record-keeping requirements for the training of non-certified applicators. This is how they can verify that the training has taken place. It's the responsibility of the licensed applicator supervising applications to create the records or verify that they exist before supervising use of a federal restricted use pesticide. These records must be kept for at least 2 years in the place of business so that they can be produced if needed. And for private applicators supervising non-certified applicators, they can just continue following the worker protection standards requirements for training that are already in place. That covers the updates to direct supervision.
If you have any questions about this presentation, please contact us at pestlicenseupdates@agr.wa.gov. You can also call the main line at 877-301-4555.
Thank you for watching this certification and training plan presentation. Stay tuned for more updates.